Our last case for argument this morning, get it out here, is Department of Neighborhood Assistance and Joel Helms. It's case number 29329. Now, Mr. Helms is here pro se, so he'll be arguing as the appellant, and the state is represented by Attorney Brian Bremer. Each of you will have 15 minutes.
Excuse us.
I think Alan, Mr. Mendick represented you,
On multiple other cases,
but not here. Okay.
He's so busy. I would love to have him represent me, but he's too busy.
So, yeah, we just want to make sure that was the case. So you're representing yourself pro se. Each of you will have 15 minutes to argue your positions. Sir, you may reserve up to 5 minutes, so that means you can divide your time, your 15 minutes, 10 minutes arguing, 5 minutes rebuttal, 12 minutes arguing, 3 minutes rebuttal. You have up to 5 minutes for rebuttal. If you're going to save time for rebuttal, just let me know. I'll keep track of that time. Also, for your information, we do have the time on the television there. So you can see your running time there. We do videotape the arguments, so we ask that you stay at the podium during your arguments and that you keep your voice up. You should also know that the court has read the briefs in this matter, and if you're ready, we're ready to proceed as well. Would you like to reserve some time?
Yes, it would.
How much?
I'll reserve the max 5.
All right, 5 minutes then. So you'll argue for 10 and you'll have 5 for rebuttal.
I think the issue here is, what is a final order? A final order is when something is put in writing. Who needs to put it in writing? Basically, the board or the secretary in its minutes. In this particular case, the law requires that the board notify myself of their formal decision. When does this take place? In this particular case, in written decision, Jody Foster supposedly informed me. Ms. Foster has no position with the board until obviously your affidavit on the 2nd of January. Nothing in the minutes or nothing in the transcript, no place does it basically designate that she's any party to the board. So the fact that she's not a party to the board, her notification, putting it in writing to me that the board turned me down, has no merit. Now, the one thing that does have merit, obviously, is the paper that the board signed. They say they're turning me down, but they're also turning me down based on the minutes. And that's what we're trying to determine here. And I also repeat that, or mention that they're turning me down not on undated paper. So when we presume that it was on the 18th, because that's what Jody Foster said it was later. But because they specifically said, based on the written record, that form on the 18th of September wasn't their final decision. They had to wait for the minutes to be done. And that's basically, without it being in the minutes and or written down at that point in time, that was not a final decision. So their final decision had to be based on the minutes as they put in their own letter that they put their signatures to. And essentially, I mean, Jody Foster's letter to me was nothing more than I would have read in the Beacon Journal the next day or something like that. Her letter had no power of law. Had she put down there secretary to the board or something else after her name, then it would have been something that could have been representative of the board. But in this case, she did not represent her as a statement from the board. And that's about what we have here. And that's the delay was, is there something to appeal, and trying to get the minutes of why they appealed, what their decision was. Their opinion of turning me down could have been totally in my favor, but not seeing what their minutes were in the facts or anything else. I couldn't go forward until I had something in front of me. I thank you very much.
All right, you'll have a full 5 minutes for rebuttal if you need it. Counsel, you'll have 15 minutes.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. I
As an initial matter, I wanted to touch on something that Mr. Helms raised. It's about the letter, the notice that Ms. Forrester gave Mr. Helms at the meeting. Mr. Helms is arguing now for the first time that that letter does not that letter is improper because of Jody Forrester not identifying her position. That argument has never been raised until this oral argument. He did not raise it in his brief, and my recollection is he did not raise it below. In any case, because he's not argued it in his brief on appeal, he can't now raise it for the first time in oral argument. And for that reason, that argument should be disregarded. But even if this court were to consider it, Ms. Forrester is actually, as she puts in her affidavit, she is the secretary for the board. She's the keeper of the minutes, she's the keeper of the record, and this is part of her duties involve giving out the notice at the hearing and sending them out subsequently. That includes the notice that she gave Mr. Helms at the time. And for that reason, when she handed that notice to him, that constituted the written notice of the decision that starts the 30-day time period for administrative appeals. When that happened in this case, Mr. Helms had 30 days from when he was handed the notice to file the appeal. The notice was actually sent again, along with the findings of fact and conclusions of law that he is speaking of in his appeal. The next day, it was sent in the mail. So, in both cases, he received this on 2 different times. Once was in person, once was mailed, and then I think Mr. Helms would agree, he didn't file anything, he did not file his notice of appeal until more than 30 days after those 2 events. Mr. Helms is arguing that those events did not begin the time for his appeal to run, but I don't think he would disagree that his appeal was filed well after those 2, after 30 days for those 2 events. I'd also point out that Mr. Helms has not cited a single piece of authority in his entire brief. An appellant is required to actually support his arguments with citations with applicable authority. He has not done so here, and for that, and while Mr. Helms is pro se, he does have to abide by the rules of appellate procedure, and under those rules, he needed to cite the authority. Because he has not done so, he has not really supported his assignments of error, and they should be overruled on that basis as well. I would also point out that when you read the briefing, the city's position is that the notice that Jody Forrester sends out is the notice. It is a notice of the written decision. The findings of fact and conclusions of law that is sent out as well. That is not the written decision of the writing of the decision of the board. If this court were to consider that the decision of the board, it still is a written decision. There might be some issues with it, as far as Mr. Helms is basically raising the argument that he doesn't feel that there's sufficient findings of fact, but that's a basis to supplement the record once it got up to the common pleas court. That's not a reason to toll the time for the actual filing of the notice of appeal. Mr. Helms, when he files notice of appeal, the transcript would be prepared, the record would be put before the court, and then he'd be able to evaluate whether it needed to be supplemented at that point. But he still needed to file the notice of appeal to actually bring the court's jurisdiction into being, and he needed to do that within 30 days of receiving the written notice from Ms. Forrester. I would also point out that Mr. Helms' third sign of error, it's unclear what he's arguing in his second and third sign of error. We point this out in our brief. He raises the issue of parliamentary procedure, he raises an issue about professionalism, but again, it's unclear how these tie into whether or not the notice from Jody constituted a final appealable order. With that in mind, we believe that the trial court got this right. Mr. Helms had to file within 30 days of Ms. Forrester handing him the written notice of the board's decision. He was then sent that notice. In both cases, he did not file until the 30 days had passed. Under the facts of this case, the trial court was correct to determine that it lacked jurisdiction over his appeal and dismiss it. If there are no questions, I would respectfully request this court affirm the decision of the Suffolk County Court of Common Pleas.
All right, thank you, counsel, and Mr. Helms, you'll have 5 minutes if you need it for rebuttal. Up to 5 minutes, I should say. Take as much of that as you'd like.
Okay. In my rebuttal, I did raise the point that Mr. Foster was not, at any point in time, representing the board, or at any point she showed she was representing the board. That was raised in the rebuttal. Now, the very nature of what took place in the hearing, which is not in front of you guys today, was why I went to the board the day after the hearing to find out what's in this record that the board totally ignored every argument I put forward. They actually denied that I put an argument on each one of the cases. The whole thing was a very strange hearing. They didn't even know their own law. But, so I reviewed the record, and basically it's saying, okay, here's the decision, here's a paper that's been signed preliminarily until the minutes are there. But if you're saying they signed this and the minutes aren't there, this is the third case, did they not in fact misrepresent themselves that they're making a decision based on something they never saw, that wasn't available for over 2 weeks later? So that's the professionalism, and I did research, and I basically couldn't find that any place. I mean, lawyers don't allow that to take place in the courtroom, so obviously I couldn't find any cases on that. So I'm sorry I couldn't find a case on professionalism. A lawyer gets disbarred if he doesn't do the right thing. But that's the nature of that. As for what a final decision is, again, it's well known in the dictionary, case law. Again, I couldn't find any research on what is a final decision, except that it has to be in writing. In this case, it was not in writing. They specifically mentioned in the minutes. Now, I put up in the air, do you have to have the minutes approved or just a draft of the minutes? But when these 5 people signed that paper, there was no draft, there was nothing in front of them in writing that they could reference. So therefore, that is the, quote, fraud, and it could not be considered viable until those minutes were there. I really think that's about it. There's a couple other notes, but they're not irrelevant almost. I think I made my point. All right, thank you very much for your guys' time.
No questions, so thank you both for appearing today and making these arguments. The court will take this matter also under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and you can also check for the opinions on the Supreme Court of Ohio's websites where the opinions are posted. Now,